of McDonald against Newton or McDonald.
Yes, Mr. Mitchell.
Good morning, my lady, my lords. I appear with Mr. Spear for the appellant, Mrs. McDonald. Mrs. Scott and Mrs. Malcolm appear for the respondent, the initial pursuer in this action. The case has been set down, as you are aware, for a half day, which may be more than enough time to deal.
Oh, that's good news, Mr. Mitchell. You have both put in extremely clear, not over long, but not over short either, written arguments, which you can assume that we have read, and we've also read the judgments in the courts below. So.
Thank you. That had certainly been my purpose. So far as we are concerned, the question here is a very short point of statutory interpretation of language, which is practically one of first impression. The respondent's position may be different, and maybe one will seek to take you into the more or less abstruse areas of the Scottish law financial provision on divorce, but that's a matter for Mrs. Scott. So far as we are concerned, this is a question simply of the meaning of a single word or a single phrase, one may regard it as either, in Regulation 4, which you have read, and simply to remind you is at page 126 on the memory stick. It's in fact reduced twice. The core volume has the Westlaw edition of the regulations as amended, up to date, while volume 1 of the authorities has the 2000 regulations in their original unamended form. But there is
what was the reference to the amended regulations, Mr. Mitchell?
MS 126 in the core volume.
Oh, in the core volume. Thank you. Even without this, I'm afraid I haven't found that. Even without it, one was able to work out what the amendment was if one turned from 11 to tab 12 and to 13. But it's helpful to have it in the final form.
Yes. We have, of course, in the authorities volume, the original and the amended versions also of the Family Law Scotland Act. But we are concerned there simply with the amended. But looking at the amended version, page 126, the formula, that is the same in all editions. And the formula was precisely the same in 1996 and in 2000 and today, with a single exception of the addition of the state pension rights in 2000. A very quick footnote on the state pension rights. The 2000 regulations, which were published in April of that year to come into force in December, were then overtaken before they came into force by the new state pension regime. And there are accordingly two sets of amending regulations that year. These are all in the volume of the authorities. One of them came into force immediately, so that the original unamended version, the full regulations, was in fact never in force as such. The second, which dealt with a glitch which had been pointed out, came into force a week later. But in any event, we are looking accordingly at the formula on page 126, A, B, and C.
Mr. Mitchell, it refers to relevant state scheme rights. Perhaps we don't need to trouble with what are irrelevant state scheme rights, but would you like in very simple language to explain which state pension arrangements come in here?
Yeah, the ones that came in were what were called SERPs, the State Earnings Related Pension Scheme. I think there may have been one or two other elements of state pension that came into it, but essentially it was the earnings-related elements in the state pension. The basic state pension did not come in. with changes in the pension regime in 2016, there have been further changes in how state pension rights are dealt with. But the underlying thrust of this has been that ever since this came into force, it has dealt with occupational pensions, with personal pensions, and with UK state pension rights that are in a sense analogous to this in that they are dependent on a contributions history. Putting it shortly, because it is very much a footnote to a footnote, the contributions history was as significantly based upon the periods of time as it was upon the actual amount of contributions. Even now, reminded of this looking at my own recently, it's a critical question just to ask how many years. And that now, in fact, matters more than the question of how much has been contributed by way of national insurance contributions. But in any event, looking at this, there's a slight difference in the language, which, to take my Lord's point, the period of membership in a pension arrangement deals with the occupational and the personal, and the other one is the period in which the party has held relevant state scheme rights. And we say on that that is not language, has held rights, that is capable of being referred back to some metaphysical concept of active membership of, I suppose one would just say, the United Kingdom community of people who work or people who have pension rights. But that is the critical point. Putting it very shortly and, and listening to my lady's flattering description of our case, I hope I've, in a sense, said practically everything that could be said on this already in my case. We say that the point could not be clearer. Membership is membership. That there is no need for an elaborate attempt to decompose membership into what in some contexts may be its components for other purposes. The draftsman, we say, was well aware that in principle membership might be decomposed into elements: active membership, deferred membership, pensioner membership, and so on. Was well aware that these were concepts, classes of membership, which only had force in the context of occupational pensions and not of personal pensions. Was well aware that there was also a practical distinction to be drawn in valuation between pension funds which were or were not already in payment at the date of valuation. And regulations 2 and 3 deal with these matters carefully and exhaustively. It has to be said for the respondent that the draftsman nodded between Regulation 3 and Regulation 4 and had forgotten by the time Regulation 4 was reached these careful distinctions. In 1996, I should say, the 1996 edition, Regulations 3 and 4 were simply paragraphs of a single regulation. But as I say, our argument, in a sense, can hardly be elaborated upon, and I look with some disquiet that I managed to do so over so many pages in our case. The respondent's argument is that the concept in Regulation 4, the period of membership of the party in the pension arrangements, is intrinsically ambiguous. They require to say that, to get into their alternative meaning, which has changed slightly, perhaps not terribly significantly, during the course of litigation. Their present case appears to be a recognition that the occupational pensions divisions between active membership, deferred, and pensioner membership, which I explain in my case, cannot be the line of distinction, because they appear to accept in their case, Mrs. Scott will correct me if I'm wrong, they appear to accept that these are not concepts that have force in the context of personal pension rights. And they appear further to accept that if one is glossing the concept of membership, one must gloss it in the same way for all categories. And accordingly, we end up on the respondent side with a glossing that it is not the period of membership in issue, but it is the period in which contributions were being paid by or on behalf of the party in question to the pension arrangement. I will mention slightly later on in my argument the next logical hurdle that reaches. But that is their argument, that the concept of membership comes back to the period in which contributions are being paid, that it cannot cover the pensioner members or the deferred members. Now, that argument, one may reflect, comes very close to an Inco-Europe approach. And it's important, just at this stage, to note that that is not, however, the respondent's argument. They identify the references at paragraph 18 of their case at MS 63. Second part of that paragraph, where they describe the accrual of rights as equating to active membership. It is easy, they say, to see why accordingly it's been construed as a period of active membership. So it's a matter of construction, interpretation. This was the view taken by the judgments they defend. They then refer also, and in the ordinary way, of course, we would not be referring to unreported sheriff court decisions in this court, but they set it up as a straw man point to be immediately knocked down. They refer to a decision of Sheriff Kelly, which is in the authorities, I didn't take you to it, where he said that he saw this as an Inco-Europe argument, thus a drafting error, an omission. He added language. But that's not their line, so we don't need to go into the...
Well, he followed Sheriff Holligan, didn't he?
Yes, he did, yes. But he followed Sheriff Holligan in the result, but reached it by a different method. Sheriff Holligan had said you can do this as a matter of construction of an ambiguity, in effect. And, of course, what led both Sheriff Holligan and the Inner House into that was what we call the problem with zero, which we'll come to. Sheriff Kelly didn't think that was possible and said you really needed to see this as a case of omission, the Inco-Europe approach. And he dealt with that fairly summarily. It doesn't appear to be something he'd had much argument on him before. But significantly, the respondents don't seek to run that, which keeps us away accordingly from all the difficult arguments we might get into there. The passage, I should say, in Sheriff Kelly's, just to give you the reference without taking you there, is MS 343. And they then get into, of course, an argument as to purpose. very first blush, the argument here may strike one as being an old-fashioned, the sort of thing one sees in the introduction to the first edition of cross and statutory interpretation, an old-fashioned argument about the literal versus the purposive theories of interpretation, because we're well away from that. There's much they say as to purpose, which is non-controversial. We don't dispute that the phrase period of membership must be looked at in its context. We don't suggest an old-fashioned literalist approach in which the word or the phrase is just lifted away from the regulation and looked at as a jewel with no surrounding tiara. We look at it in the context of the regulations, and importantly, the earlier regulations, which make clear the draftsman's consciousness of these fine distinctions. We further don't dispute their account, how it came about that the regulations came to be enacted in the first place, which is at paragraphs 14 and 15 of their case at MS 61. Where they say, uncontroversially, that property, correctly put in quote marks because it's questionable how far this is to be regarded as property in truth, in the case where pension differs from other assets, where a spouse does not have any interest in an underlying fund, merely a right to future benefits which are defined by the particular pension arrangement. They say rightly that the Scottish Law Commission report, which Professor Clive was really, I think, the lead author, declined to recommend a basis of valuation. They put in the relevant sections of that report. They rightly say that in the early days of the 1985 Act, problems emerged. The first was the expense incurred in securing actuarial valuations. The second was controversy over how pension rights should be valued. It was in a sense a subset of the first. Different actuaries had different theories, and these might be applied differently to different facts and circumstances. And there is no dispute that, as they say, these problems were inimical to the intention of clarity and certainty. They're also deeply inimical to the ordinary concern of the litigant with cost. Had Mr. and Mrs. McDonald been seeking to divorce in 1990, each of them would have had to instruct actuarial evidence. This might have been controversial. We see this in all the cases in the bundle, starting with little against little, rival actuaries giving expert evidence at substantial expense. Rather extraordinarily, there was actuarial evidence on both sides in this case. It's fair to say that that is exceptional these days. The purpose on the respondent side appears to have been to get Dr. Pollock, their actuary, to give supposed expert evidence as to the meaning in law of the regulation. But that's long gone. There was an attempt to found upon his evidence of law, which we're no longer concerned with. In reality, we now have a situation in which, for better or worse, one just reads off the regulations, what the figure is, one jots it down in a notebook, and there you go. They accordingly rightly say that these difficulties were resolved by the insertion of Section 10(8) into the 1995 Act, which they have for present purposes sufficiently quoted, and the 1996 regulations. They rightly observe that this prescribed the use of the cash equivalent transfer value, albeit that was notoriously in many cases of occupational pensions where there were defined benefits, a gross underestimate of the true value. And for reasons which I have to say, with all respect, rather escape me, they put in some examples of that unfairness in unreported Sheriff Court decisions of the time. An army sergeant who had a very small cash equivalent transfer value was plainly entitled to benefits of much more value than that, but his wife could only get into half of the cash equivalent transfer value. They note the history of amendment. They rightly say that the point of the whole exercise was to allow for pension rights to be valued without excessive expense on a clear and certain basis, namely the CETV, and one might add also, of course, on a straight time line which could be obtained immediately from the pension fund provider. And that the apportionment exercise has been repeated substantially since 1996, with a single exception of how state rights are dealt with. So we agree with all that. And further, going a little bit further, we don't dispute that here, as in so many areas of law, bright lines of this kind may serve the interests of parties in the avoidance of unnecessary expense, and from the court's point of view, lead to a proportionate approach to litigations about perhaps relatively small sums, but nevertheless may not achieve perfect fairness between the parties. Perfect fairness, as so often, may only be capable of achievement, if at all, by inordinately expensive actuarial evidence, coupled potentially with medical evidence about when one might expect parties to survive to, and so on. And ultimately, all one ever has, of course, is a crystal ball in any event, taking the ultimate value. But we don't dispute that any attempt to set a clear and certain basis on valuation and apportionment, as these regulations do, is capable of being criticised by individual litigants in individual cases as not giving them perfect fairness. But the truth is that it is a bright line, and critically, as I've said more than once in my case, I needn't take you back to the passages. This proceeds in two stages. The logical first stage, the total valuation of the pension fund in question. Secondly, the apportionment, which, as we see, and in a sense this is really what they object to, apportions on percentages of time, not on the basis of contributions. It is clear that a different drafting approach might have led to a Regulation 4 that had a formula based upon the percentage of contributions to a pension fund before marriage and the percentage after, in one way or another. But the regulation simply doesn't seek to do that. It might have been a better regulation, it might not. And I gave in my case as one example of how this bites. The person with a personal pension scheme who pays in a total over their life before separation of 100,000. Over a period of 20 years, 10 years before marriage, 10 years after. In one of these periods it's 99,000 and in the other it's 1,000. On any view, there is a 50-50 division with a timeline, on their theory as on ours. And that is the same whether it is 99,000 before marriage and 1 after, or the other way round. And that is visibly obvious in the nature of a timeline leading to the apportionment rather than contributions. And all that they can say upon this is that there are, however, other cases such as today where a contributions-based approach is more closely approached by their theory than by ours. We ask then, why do they say this? Why do they say that one cannot simply reflect that membership means membership in Regulation 4, that the draftsman was fully conscious that there were categories of membership? Their argument on this had been one of language, the problem with zero, which led Lord Malcolm and Lord Abercrombie, I needn't take you back to these, it's paragraphs 45 and 48 respectively of their opinions, to say that the linguistic problem of the zero could not be reconciled with membership simply meaning membership. Accordingly, they said, one must reject the straightforward approach to language and search for an alternative meaning which was reconcilable with the zero problem. And one can appreciate that if one teases out of Regulation 4 a nugget of language which makes the simple application of language impossible, one must look for something more convoluted. What I say on that is that we have answered this with our description in paragraph 20, with the relevant date. That's at page 47 to 48.
Far-fetched, isn't it, Mr. Mitchell?
Well, I've tried to put in a few examples, or rather some more colourful than others, into the footnote. It does appear from, I should say straight away, incidentally, because we want to give credit where credit is due, this is Mr. Spear's idea. He's thought of this, sadly not before arguing in the inner house. He thought of it afterwards, and we thought that has to be right. It happens. I said at the beginning that one need not go to the tabloid tales, but in fact, if one searches, there's plenty of such examples, and indeed he gave me one or two of rather scabrous stories from the popular press of unfortunate wedding receptions which had led to this. But the basic point we make is it may be far-fetched, it may be, as the respondents say, exotic. One may speculate as to the draftsman's awareness of the Pushkin plot, or one that occurred to me later, Sir Walter Scott, the Lady of the Lammermuirs, who stabbed her husband.
Yeah, but I mean, assume that we're not terribly convinced by these examples, and we don't think that the draftsman was really thinking of that. Yes. Where does that leave your argument? I mean, assume we can't solve the problem of zero. Where does that leave your argument?
Well, where I say it, firstly, is that these arguments may be far-fetched, but it's the purpose of good drafting to deal with far-fetched examples.
Yeah, but forget about that.
Yes, forget about that.
We're against you on that.
If you're against me on this, if you came back to where this was at in the inner house with the speeches of Lord Malcolm with the opinions of Lord Malcolm and Sheriff Principal Abercrombie, one would say that you have an intractability of language, that the draftsman appears to have said different things in the definition of B and the definition of C. And we will come back, I think, to a reflection that somehow or other one must then reconcile this by, in a sense, a preference for one. But the draftsman has still used the concept of the period of membership when he was well aware that membership covered different categories, and that is really the guiding point. The language in the definition of B is very, it almost might be said to be on both parties' arguments a redundancy. If there is no such period, the period shall be regarded as zero. Well, of course it will. I'm not quite clear why any party's position upon this. One needs to say, if it's zero, then it shall be zero.
I mean, if it ends up as redundancy, does it actually matter to anyone?
It wouldn't. It wouldn't, no. What the respondent, I think, is constrained to say on this is that it is there for a real reason. And their reason appears to be that the draftsman, in an extraordinarily obscure manner, is choosing to put into the definition of B language which then gives you a definition in C of something different. It's an extraordinary way in which to cut down the phrase period of membership. And we would just say he or she cannot have been intending to do so. And one just comes back with a shrug to the throwaway language in the definition of B and say it goes nowhere.
If the Rudolph Valentino line isn't accepted, then the B and C are interpreted as in a house in terms of what the period that's being referred to as zero, then if B was zero, C would have to be zero in those circumstances.
That's right. That's the problem. Lady Smith came up with a way in which one dealt with the problem within B, but as rightly pointed out by the respondents, it did have the consequence that C would be zero as well. And so, you know, that's right, that doesn't really...
But what's wrong with B and C being zero?
Oh, we say there's nothing because we...
X times naught over naught is naught.
Yes.
So why is it said that Lady Smith's equally exotic example fails because C might be zero as well as B?
It's a matter for the respondents, I think, rather than me to say why it fails.
I thought you conceded that her example failed.
Yeah, I concede that it doesn't work because it doesn't serve my purposes in argument. Because ultimately, having said you can explain away the language in B, she, with great respect to her, fails to notice it creates a knock-on problem in C. But the critical question is here about looking at the language in C. We are seeking for the meaning of the phrase, the period of the membership of that party, or as the case may be, the period in which the party has held relevant state scheme rights. And it's a very peculiar way of explaining that, to say that like a crossword puzzle clue concealed in an earlier definition is a clue to what is meant by membership in the way which is explained perhaps most clearly by Lord Malcolm.
Yes, Lord Malcolm rejected your approach because he said that C had to be a positive number.
Yes.
Is that correct?
Yes, yes. And on any view there has to be, whether one cuts down membership or not, if there is no period of membership of any kind in the scheme before the relevant date, then there won't be a pension fund in the first place.
God.
Because in C, one is looking at the period of the membership, effectively from its inception up to the relevant date.
Yes. The result doesn't bother you. If B and C were both zero, then it would be an equitable result because A times zero is zero.
Well, we say that's not how it works, I say, because we say that what we're attempting to get in this formula, looking at C, it cannot have occurred to the draftsman that one is defining C, the period of the membership, in a way that brings out a zero.
Because if you haven't got a membership at the relevant date, then you're not into Section 10 at all.
Absolutely.
Precisely,
Nobody looks at this. Yes, yes. And looking at a strict way of working it through the regulations, if one was being so pointlessly painstaking as to work one's way through it, you'd hit that at a Regulation 3 valuation point.
Yes.
Who do you even write the letter to? Nobody. But clearly there has to be a period of membership, and that is so, there has to be a period of membership on either side's construction in C.
As at the relevant date.
We say that standing there, that the phrase used is the period of the membership. That just means what it says. The narrow statutory context is the definition of C. The wider statutory context is the regulations as a whole.
And Mrs. Scott says the still wider analysis should bring in the general way in which your scheme works. And she says, look, we're talking about passive growth here.
Yes.
If the husband before the marriage has shares worth £10,000 and he keeps those shares throughout the marriage until after separation, and on separation they're worth £100,000, that's none of it matrimonial property.
That's what she says.
And so she says if passive growth works that way in relation to the Scottish scheme for financial provision, then analogously it should work where the passive growth is in the pension rights.
Absolutely. The logic of her case is to say, in a sense, the regulations don't matter, that although she's already conceded in her case, pensions are different to other assets, that one must nevertheless say that one must force this into the straitjacket of how one would look at shares or the fine art on the walls. Taking shares, there is in fact a little bit more problem on shares than she appears to accept. Her analogy on this, in her case, if I can just point you to that. Is example 1 at MS page 65.
Yeah.
Provides an asset, which clearly is not a pension fund or a matrimonial home or furniture. What he's bought is a sofa to put in the... We know all this. There are differences. It's a key to the whole way the scheme works between classes of asset. On divorce, that asset is not matrimonial property. Yes, that's correct. It matters not whether the asset has increased in value. Yes, that is correct too, albeit identified in the article by Professor Clive, which we have in our authorities, as being a well-known problem with the way the law works in this field, which has so far not proved capable of solution. Even if the asset was a share, or one might say a packet of shares in a company where profits were retained, that's in fact slightly more complicated. If it's shares which were simply subdivided, the growth is kept entirely within the company, that is so. If profits are distributed, they come out by way of dividends. The dividends go into the matrimonial pot as income. And so what one has on two different companies, one of which, perhaps an American shareholding, has a cash mountain and doesn't distribute. No part of the increased share value is matrimonial property. The other, which distributes its profits to the shareholder year by year, with the result that there's no particular increase in the underlying capital value, what has come out, the increase in value, is matrimonial property.
You mean if the dividends are paid and then saved? That's matrimonial property.
Absolutely. Of course, if they're not saved, they're simply not there at the relevant date.
If the dividends are spent, then, well,
It's just
So what you're saying is if the profits are simply retained, it is the equivalent of paying dividends, of the dividends being reinvested, and it's still matrimonial property.
yes, if it stays the same. Equally, the Rembrandt on the living room wall. I have that before I get married. I don't, but I have it on my wall in the example, and I keep it throughout. I still have the same thing at the relevant date. The fact that it's gone up in value makes no difference. It's not matrimonial property. If I've been selling tickets to view it, I have made profits from it. But all that this perhaps shows is that cases vary, cases differ, and critically on this, there's no particular reason why one should say that one must force all classes of property, whatever their treatment, however they're held, into any particular straitjacket. Can I give you another example on this? Example 3. R becomes a member of the occupational pension scheme. They say no contributions at all made into the original scheme during the marriage. They are correct on their theory that this leads to the result on their side, that this is not referable to the period of marriage, neither the original element nor the growth, because on a timeline apportionment, we know what comes out. There'll be something. But what if he has, as is common, transferred that into a SIP?
Yeah.
On their logic, he changes his employment prior to marriage. He has a pension fund sitting there. He accepts advice that he should take out the CETV and put it into a SIP after marriage. The old pension fund has ceased to exist, and accordingly there is nothing there to be taken into the calculation at all. But the new one is 100% after marriage. Now, that is so on both parties' construction. Yeah. And we point out that the solvent for all these difficulties is the use of arguments as to special circumstances, which are protean. Now, we needn't, I think, go here into how special circumstances work, because it's common ground between parties that in this particular case there may or may not be an argument of special circumstances, and because that wasn't considered before the courts below for logical reasons, and it wasn't considered as a fallback, it has to be reconsidered before the sheriff. But all of these positions, looking at the facts of a particular case, are open to the respondent.
Lord Malcolm and the Sheriff Principal both seem to think that even on their disposal, special circumstances would come into it and might rescue your client to some extent. That was just wrong, wasn't it, Mr. Mitchell?
Just wrong. It is sometimes said, I don't want to enter into this, to be a flaw in the Family Law Scotland Act that special circumstances only bite when one's already identified the pot of the matrimonial property, the kitty. One, as my lady and my lords are well aware, a key difference between the English and Scottish regimes is how they deal with the gold digger who marries a man with enormous inherited wealth. I put it that way round because it's the more common.
The person who marries.
Yes, yes.
The person with enormous inherited.
No, I'm showing.
Could be for love. You never know.
There are reverse cases which are quite prominent and quite well known.
Yeah. Indeed.
I was very intrigued reading this to see to what extent a spouse could get an award referable to non-matrimonial property.
Yes,
and I wondered whether she or he could sometimes get it under section 9(1)(b), economic
Yes.
advantage?
Putting it shortly, they can. I'm aware, I read my Lord's article on this a few weeks ago, which was, if I may say so, interesting, but not ultimately informative on the Scottish law, because it is different, so different. And Scottish law has had, at the root of it, a key broad proposition that one has to identify the distinction between matrimonial property and non-matrimonial. But as my Lord rightly says, you can get back into this with economic advantage and disadvantage.
But that may not be easy.
It may not be easy.
Thank you.
It's frequently said, and Professor Clive identifies this as an error in perceptions of the profession, to be an underexploited provision of the Act.
I mean, what he said against you, rightly or wrongly, is that the scheme of Scottish ancillary relief differs from the English in this, at least, that it is based very much more on certainty of approach and very much less on flexible discretion post-divorce.
Absolutely.
And that, which is clear, and that accordingly, reaching for section 10(6) is not a satisfactory solution and cannot have been intended to be the solution to the definition of matrimonial property.
Section 10(6) was identified by Lord Malcolm and Sheriff Principal Abercrombie wrongly as a solvent, whichever side of the argument one approached it from. We say it's a solvent on our side, but not on theirs, and I think that's accepted.
Well, potentially, yes, but the argument, as I understand it, is that you shouldn't have to get to 10(6). With things as common as pensions, you need a firm concept of what's in the pot and what is.
Oh, indeed. I mean, clearly, it's the ideal solution, of course, for everybody is that you simply jot this down. You jot down the tabulation on the back of an envelope, and you read off the arithmetic.
Well, you would say that on your construction, it is extremely simple.
Yeah.
Yes, indeed.
The application of the formula.
The calculation on the back of an envelope is extremely simple. Yeah. And if somebody wants to complain about it, they can, as always, when they say that's too much, look at special circumstances. Or, as Lord Wilson points out, they can start to go into the economic advantage and disadvantage arguments. Yeah. Another flaw in the Scottish Act, by the way it draws lines, which is relevant to my Lord Wilson's point, is that it does not recognise the consequences of periods of cohabitation before the marriage. One draws a line on the pension fund, for example, on both sides' formula. There is a line drawn at the period of marriage. Now, for all one knows, parties may have cohabited for decades beforehand. Now, as we know, and this has come, of course, before this court, cohabitees in Scotland have remedies which are in effect constrained to a variation of the economic advantage line of argument. But it would be hard in that context for somebody as a cohabitee to run such a line into the pension fund because they have not been disadvantaged by the mere fact that the man has the asset and the woman doesn't, or vice versa. Professor Clive's article on this makes the point, however, that nobody is suggesting this is a perfect scheme. It has elements of discretion. There is a need to reconcile principle and judicial discretion, which is fact-specific. I don't know that I can sensibly elaborate upon this. It is plain on the structure of our system that it broadly seeks to do that. But stepping back from that broad line of argument for the respondent, the thrust of everything that they are saying upon this seems to come to this, that if this had been a shareholding, if this had been fine art on the walls, it would have been dealt with in a particular manner. Therefore, it cannot be correct that one has a result that deals with rights in a pension fund differently. Of course it can. the different nature of pension funds has been accepted from the beginning. As they rightly observe, there was perceived difficulties coming out of that led to the 1996 regulations and the imposition of bright line methods and later fine-tuning, which we don't see in other classes of property at all. Their argument seems to come to this, that the regulations effectively have no content, that one must lead to an approach to valuation which is the same as it would be if it was anything else. And one may reflect that if that was right, it is very hard upon the claimant in these cases that they are nonetheless held to what may well be the very unfairly low CETV rather than an actuarial valuation, because if one needs to bring in actuaries in this way, why should she not be permitted to say to an actuary, but how much is this really worth?
Has your client got contingent widow's rights in the husband's pension scheme?
Yes, this is a scheme which has widow's benefits as part of it.
When I say has, I really meant had prior to the divorce, or perhaps there hasn't been a divorce yet. But until divorce, if he was sadly to predecease her, would she have a widow's pension?
Yes.
Under the British Coal Scheme?
Under the British Coal Scheme, yes.
So that on the inner house's disposal, her contingent rights, which of course will fall on the divorce anyway,
yes,
get, as it were, eliminated. Is that?
No. The materials in the authorities bundle are capable of confusing on this. The pre-1996 position was that there was a judicial dispute as to how one regarded the widow's benefits. There were cases that went both ways. There were arguments that went both ways. Ultimately, that was resolved by the inner house in the case of Dybel, which is in the bundle, that said that the contingency upon which the widow's benefits depended logically had disappeared at the moment of divorce. And accordingly, if one had, say, a typical pension fund that said you've got a total value of £200,000, of which 50,000 is attributable to the widow's element, one valued it at 150. Now that was very good news, of course, for the person who kept the fund, who could then recreate that value immediately by remarrying. And it was that perception which was rejected by the inner house. That was, however, then changed by the 1996 regulations, which brought this back in to the valuation achieved. Again, there are rights and wrongs and fairnesses and unfairnesses, no doubt, upon both sides. But it did it, again, by a simple, absolute rule. You looked at the total value of the fund on the assumption that there were widows, that there might be widows' benefits as the scheme provided for.
Mr. Mitchell, I don't think, I'm sure it's my fault, I don't think I fully understand the answer to my question. There's no divorce at the moment.
No, there isn't.
There isn't. So, right, there's no divorce at the moment. So if the husband were today to predecease your client, she would have rights.
Absolutely.
Under the British Coal Scheme. Under the disposal upheld by the inner house, she derives nothing from that loss of contingent rights.
Absolutely. And one might see this more clearly, slightly uncomfortable talking about the death of somebody who's present in the room.
Well, I apologise about that. I really do.
No. Take her example, her example 3 of R, the man who changes his employment prior, this is at MS 66. The man who changes his employment prior to marriage, and then there's no contributions during the marriage. And then divorce proceedings are brought. And then before they're finalised, he dies. His widow is his widow. Her rights have not been terminated by divorce, and accordingly she gets the widow's benefit from this, if there is one. Typically, of course, under occupational pension schemes, there is a widower's benefit, not universally. And so she does acquire what would be said, I suppose, by Mrs. Scott to be a completely unearned windfall from this. There is no decree of divorce until the litigation is final. Possible, I should say, procedurally, to engineer a situation in which there can be a decree of divorce with financial provision, questions still to some extent being there to be settled, but we're not in that territory. But I don't know if I can say much more about it. Examples can be multiplied endlessly, and one simply returns to the reflection that they're only examples of particular fact situations. Particular fact situation which we have here gives the wife, in effect, a share of the pension fund, which does reflect the fact that this is an asset which cannot sensibly be divided into pre and after on the basis of a contributions history. It can only be done on a timeline. And I have given my riposte to how examples work that demonstrate that this is a timeline and not contributions. And just to wind up, perhaps, on examples, their entire emphasis on this is on the occupational pensions. One cannot have a solution that is based upon occupational pensions to the exclusion of other forms of pension. Taking the personal pension example, the period during which contributions are being made may be utterly serendipity. On their construction, we have perhaps somebody who was paying money into a personal pension before the marriage. Years go by after the marriage in which no contribution is paid into the scheme. And then, as it happens, a short time before the relevant date, he has a lump sum for whatever reason, or she has a lump sum, and that's paid in. It may be a very small sum. How do we deal with this on the respondent's argument? They have no answer to this. They appear to take the view that the day before he pays in that sum, the percentage, the period of membership after marriage is 0. But then the day he makes that payment has then retrospectively created an aura of membership over the entire period. And a number of formulations have been used on the respondent's side, which all come back to that basic problem. Lord Malcolm came up with I think it's accepted, the practically unworkable idea that it was determined by what was in the mind of the pension fund member. One looked for the positive decision to cease making payments. Utterly unrealistic, of course. The person who over the years is not making payments never puts their mind to the question, in truth. What happens on their theory? If the person with a large private pension scheme, they haven't, as it happens, put in anything since the marriage, but their partner, acting on advice, makes a payment into this and then says, darling, part of your Christmas present is that they're paid money into your pension fund. Because by doing so, on the respondent's theory, she acquires vast value, potentially. None of this makes sense. We return ultimately to the problem that one can see anomalies in all of this. And all we say on that is that, yes, there will be anomalies in any approach. There will be a lack of perfect fairness. But the core to what the regulations were seeking to do was to get away from the Rolls-Royce expensive approach to perfect fairness. And that, for better or worse, was seen by taking a timeline, a time sharing, rather than a contributions sharing, which would clearly have been possible. One could normally get a contributions history. But it would equally clearly have been slightly more difficult and expensive, and possibly in some cases much more difficult. I don't know that I can really say anything much more in support of my argument. You have my case. I regret that you don't consider the Rudolph, if the courts, if my lady and my lords don't consider the Valentino example to be better than exotic, so be it. But it is nevertheless the sort of contingency with which draftsmen deal. And all we need say on that is that it gives a meaning and gets away from Lord Malcolm's approach, that the starting point was that no meaning could be given that would allow one to read period of membership as period of membership. As soon as one sees that period of membership may be read as period of membership, the respondent's argument, which is founded upon the intrinsic ambiguity of the concept, falls away in its entirety. But in my submission it would, even if we don't have our answer to the zero problem. I'm well ahead of my time. I'd allocated 90 minutes, and I thought at the time it would probably be excessive. But unless I can assist the courts further, these are my submissions.
It looks as if my lords have no further questions to put to you, Mr. Mitchell. Thank you very much indeed. Mr. Spear, you follow?
Well, I've nothing to add.
Mrs. Scott.
Lady and my lords have my proposition that the period of membership of that party in the pension arrangement means period when contributions are being made by or on behalf of that party to the pension arrangement. And we say that because, first of all, we say it's consistent with the terms of the regulation, that the appellant's so-called literal argument ignores critical parts of the regulation. And we say it because it's the interpretation that in our submission best fits with the context of the Family Law Scotland Act of 1985. And with my lady and my lord's permission, what I propose to do is to focus, first of all, on the 1985 Act, then look at the regulation in a little more detail, and then move to the final interpretation point. The arguments do meld together. It's very difficult to deal with one entirely separately from the other. But if I might start with the 1985 Act, I reject entirely that this is abstruse. There is, in fact, in this case, an important point at stake which affects every family law solicitor and every family law advocate in Scotland, and hundreds, literally hundreds of cases. And what is important to family lawyers in Scotland in my submission is that there is not a discrete scheme relating to pensions. The pensions are an integral part of a single scheme for financial provision. And the whole aim of the 1985 Act is integration and not a separate scheme. And that is why in our submission it is important to read the regulations in the context of the Act. If I might take the court to the Act as originally drafted in the Authorities Volume 1 at tab 1, Members of the court may be familiar with the fact that in Scotland we have 5 principles for determining financial provision on divorce. And the principle that we're dealing with here is section 9.1a, which is the starting point, but not the finishing point. And this perhaps answers some of my Lord Wilson's concerns about needs-based arguments, which I'm conscious are important to an English family lawyer. But in Scotland, we start with rights, division of property, and we move on then to consider advantage and disadvantage, which Mr. Mitchell has mentioned.
Mrs. Scott, you would expect me to be entirely disciplined. I come into this court and I forget and abjure the system of financial provision that I have worked in the course of my career.
I'm delighted we're all wearing kilts today. But 9.1a, net sharing the net value of the matrimonial property fairly between the parties to the marriage, is the starting point, not the concluding point. And if one looks at the way that 9.1a is to be implemented, it's not a simple overall fairness, because we're guided in the way that we do that by section 10. And what the Scottish Law Commission did when they were drafting this original version of the legislation, and indeed in the version we now have, is to bring in the proportion of rights or interests in either party in the pension arrangement to form part of the matrimonial property. So by definition, it's part of the scheme of matrimonial property. And it takes its place alongside the easier sorts of property, which are defined in 4A and B, the principal part being the property acquired during the marriage, but before the relevant date, and that, of course, is critical to my argument. And I leave aside the issue of the matrimonial home, which, of course, is brought in because engaged couples may buy a house to live in, and that, of course, should go into the pot. That's all that 4A does. And then that goes back and is gathered into 10.2. The net value of the matrimonial property is the value of the property at the relevant date. And, of course, we don't have a matrimonial property regime. We have a point of time at which we assess what goes into the 9.1a pot, usually at the date of cessation of cohabitation, occasionally at the date of the inception of the proceedings. And then that is what is shared fairly between the parties, fair sharing, usually being equal sharing. There's a presumption for equal sharing unless there are special circumstances. And I pause there because the court already has the point, I think, that the special circumstances argument, the departure from the presumption of equality as it's described by the House of Lords in Jacques, is the point of particular difficulty for every family law practitioner in Scotland. They're the hardest cases for us to deal with because we depart from the much prized certainty of the Family Law Scotland Act, and we have to advise parties on what might be fair in terms of dividing this pot, this figure that we've identified. And it causes enormous problems to family lawyers. It causes the greatest litigation. It's the most difficult. They're the most difficult cases to resolve. And the concern in a case such as this is, are we in that area of discretion and flexibility, which is going to cause difficulty, will cause difficulty, or do we have certainty in terms of the general pattern of the legislation? But as explained in the case for the respondent, the process that family lawyers go through is, first of all, to identify the property. And, of course, identification here are the rights in terms of the pension arrangement. And then we value the property, and then we deal with sharing the property. And it's quite plain from this original version of the legislation that section 10.5 is an identification section. It pre-existed the insertion of section 10.8 and the regulations, which is why I would reject respectfully part of Mr. Mitchell's case that says that 10.8 is exhaustive of 10.5. 10.5 is about identification. Valuation was a source of difficulty. Mr. Mitchell's explained this. Lady Smith explains this in paragraph 20 of her opinion. We had a certain amount of difficulty with it. We've been through a certain number of cases, and they've been referred to by Mr. Mitchell. Dr. Pollock referred to it in his evidence as he was called on as an actuary regularly prior to the 1996 regulations. But what we have from the 1996 regulations onwards is a valuation exercise in terms of the regulations. That valuation exercise is not exhaustive because, of course, it doesn't cover foreign pensions, and we do encounter foreign pensions because they can't be valued in terms of domestic regulations. We can't go along to domestic pension schemes. It doesn't value things like the old FERBs, funded unapproved retirement benefit schemes, or ERBs. It doesn't value things which appear in section 27.1 as part of the definition of benefits in a pension arrangement, being things that are not in a pension arrangement, and one encounters that occasionally in terms of a partnership agreement or a family arrangement. And so 10.8, as we now have it, cannot be exhausted of 10.5. We still require to come back to the principle. But what we have now are regulations which were designed to address a mischief. And the mischief was the disproportionate expense and uncertainty of having to deal with actuarial valuations in each case and arguments about the value of pensions. And of course, if one's looking at the mischief, I accept entirely that the CETV solution adopted is fairly crude. But that was the solution which has been adopted by the draftsman in the interests of certainty. If I might just pause briefly to pick up a point about pensions and other principles, and draw attention to the fact that if one's dealing with economic advantage and disadvantage, I'm conscious this court will be aware of that, having heard the case of Gow against Grant in the context of cohabitants. Pre-marriage cohabitation is brought in with economic advantage and disadvantage. The court will see that from section 9.2. And one can, in fact, address an economic disadvantage in relation to not having a pension, and I've done so, by securing a pension sharing order relating to partly a non-matrimonial pension. This is a complex scheme and there are all sorts of subtleties within it. We are dealing with just one aspect. It's an important aspect because it's our starting point. So that's the 1985 Act. For the practitioner, this is turning to pension valuations, we're generally no longer troubled with the complexities of valuation of pensions. We simply write off to the pension arrangement, pension scheme, the administrators, and get a cash equivalent transfer value. And the reason that we included in our bundle the Sheriff Court case of Stewart and the couple of cases which followed on from it was because the way that this is taken is apply the scheme, get the figure, and one can assume that Parliament intended that to be used. And one will not generally be able to advance a special circumstances argument to say that Parliament shouldn't have done that. And that's what the Sheriff says in Stewart, and which was followed in the case of Logan and the case of Webster. But we're not actually at that point in this case. In this case, we're looking at how much of the cash equivalent transfer value goes into the calculation of value that is in the pot for the purpose of sharing. And I accept entirely Mr. Mitchell's point that, again, this is a fairly crude calculation, but it's part of an exercise that has the purpose of reducing expense and producing certainty for our starting point. And what Regulation 4 acknowledges is that the value of the proportion may be 0. And of course, to the Scottish family lawyer, that makes perfect sense. Because if there has been a pension which relates entirely to employment before the marriage, or a private pension where all the payments were made before the marriage, it's fairly obvious to the Scottish practitioner that no part of that pension is referable in terms of Section 10.5 to the period of the marriage. And the Scottish practitioner will treat that like the investment made before the marriage and put it on one side and say it's not part of my Section 9.1a calculation. It may come in other places in terms of the other principles, and we've been rightly criticised for failing to proceed sometimes to look at the other principles, but it's not part of 9.1a. And similarly, if a practitioner is faced with a spouse who's worked for a few months into the marriage and then stopped, the practitioner's expectation, based upon the general working of the Act, is a small part of the pension value is to be included. And that's what happened here. It makes perfect sense to a Scottish practitioner, because that's the way the Family Law Scotland Act actually works. And that's why the case examples are included in my case. And that indeed is consistent with the case law, including the case of Jackson, which is cited by Lady Smith. And now I argued Jackson, and I don't quite understand the point that Lady Smith makes from that case. In Jackson, somebody sold out on a company in which he'd been involved, and in return was given a pension. He acquired that pension during the marriage, but the pension was calculated in terms of the contract by reference to a period before the marriage. And what Lord McFadden said was, he has a pension, it didn't predate the marriage, he acquired it during the marriage, and therefore the whole of that pension is matrimonial property. And he put the whole value of the pension into the pot, notwithstanding my effort to persuade him that part of it might be referable by calculation to a previous period. So the emphasis is on the reality of acquisition during marriage in that case. Now, the difficulty for Mr. Mitchell in my submission is he includes in matrimonial property, by reference to regulations relating to value, rights that are not related to any economic activity by a spouse during marriage. And that's inimical to the principle in section 9(1)A of the Family Law Scotland Act. And its interpretation of the regulation that pulls an increasing proportion of the value of pension rights into the pot, not by reference to when they were acquired or accrued, but by reference merely to the length of the marriage. And there is no other part of the Family Law Scotland Act that works in that way. And effectively, what he's doing is to make an increase in value during the marriage part of the net value of the matrimonial property. And this is my Lord Wilson's point about passive growth. Passive growth in an asset which is excluded from section 9(1)A is not part of the pot.
You use the word accrual. Doesn't passive growth accrue?
It doesn't accrue by virtue of any step taken by the spouse during the marriage.
But my difficulty, Mr. Scott, with your position is subsection 4, which sets out the general rule defining matrimonial property, looks to what has been acquired during the relevant period up to the relevant date, during the marriage up to the relevant date. But it is said to be subject to subsection 5. And subsection 5, as far as it goes, looking at what was initially conceived before the section 10(8) regulations, refers to the proportion of rights referable to the period. There is no mention at all there about the rights having been actively acquired during that period. So I find it difficult to say that, difficult to accept the assertion that Mr. Mitchell's position is contrary to the wording of the Act as initially conceived. It seems to be, on one view, perfectly consistent with it, that the references in section 5 is to the ascertainment of a proportion referable to a period, with no definition as to what active or passive events occur during that period.
I think the answer I would give to my Lord's concern about that is that we took some time to settle on the issue of increase in value of non-matrimonial property, that is property that has either been gifted or inherited or acquired prior to marriage. And there was a controversy about that, the Lord may recall, between Lord Marnock and Lord Osborne, which was finally settled in Lord Osborne's favour in the Whittam case at tab 29. Lord Osborne was dealing with Christian Salveson shares and reorganisation of that company and what had happened in relation to the value of that company. Having dispatched the arguments about whether there had been any property acquired during the marriage, he then attended to the issue of increase in value, and he did so at manuscript page 512. There is a passage between 512 letter J and 513 letter D where he considers that.
Mm-hmm.
And I think I need to take matters fairly short, where he deals with the element augmentation of value of an asset over the period of time, just below letter L, from acquisition to the relevant date is quite impractical and unwarranted, having regard to the terms of the Act of 1985. In my view, the practical difficulties of adopting such an approach as that would be insuperable. In particular, and as examples, one asks oneself the question, what allowance would be made for inflation in ascertaining the augmentation in value in real terms and upon what basis? In my view, having regard to the language of the Act, no answer to that question in particular can be found. Furthermore, in a situation where the value of some assets might have increased and the value of others diminished, it would seem to be wrong to take account of the increment in value of new property, yet to take no account of the decrease also. Again, on this matter, the Act of 1985 is completely silent. In my opinion, had Parliament had in mind the adoption of this kind of approach, it could easily have provided for it, but it's not. Accordingly, I am driven to the conclusion that the adoption of such an approach was not intended by Parliament. For that reason, in my judgment, there's no merit in the subsidiary argument presented to me by counsel for the defender to the effect that the uplift in value of the pursuer's shareholding in the company between the date of acquisition of the shares concerned and the relevant date should be regarded as matrimonial property. And that now is the generally accepted position. It's been the generally accepted position since Lord Osborne decided it.
On the interpretation of Section 10.4.
As an interpretation of Section 10.4.
Yes, which is subject to Section 10.5. And pre-regulations, one interpretation of Section 10.5 might have been that you have a valuation in a Rolls-Royce system of those rights as at the date of the marriage. You have a valuation as at the date of the relevant date, and the difference between the two could have been ascertained.
I think my answer to my Lord is that Section 10.5 falls within a system, and it would be surprising if it was interpreted differently from Section 10.4. And it was not
But why do you say it falls within the system? Because I mean, it is subject to 10.4 is the system, and 10.4 is subject to 10.5.
They're both dealing with matrimonial property.
Yes, they're defining matrimonial property.
But, my Lord, if I have £10,000 and invest it in a share before I get married, and that share increases in value during marriage, then the increase in value is not matrimonial property. Why should it be different if I put that £10,000 into a pension fund and don't touch it during the marriage? But if one's looking for consistency in the way one deals with legislation, one would say that one would deal with it in the same way, whether one put the money into a share or into a pension fund.
Parliament could easily have provided for that if they'd said in Section 10.5 that pensions were to be valued by reference to the rights acquired during that relevant period. The rights actively acquired during that relevant period.
If one looks at what the Scottish Law Commission was concerned about, it was concerned about savings during the marriage. That's what they say in paragraph 373 of the actual recommendation. And if one's
That's tab 33.
I think so, yes.
Yeah.
Page 547.
Yes.
5,
Page 5, manuscript page 547.
5. Sorry, I didn't hear the middle of the numbers that you said.
547.
547. Yes. Thank you.
Yes, in 373 it talks about rights under life insurance policies and similar arrangements being built up partly before and partly after a marriage. In such cases, we think that only the proportion which is attributable to the period between the marriage and the final separation should be treated as matrimonial property.
Yes. I can see that's ambiguous in terms of my argument.
It is ambiguous.
Yes, yes.
Could I put an example to you, Mrs. Scott? Let's pretend I'm a member of a private pension scheme. Mm-hmm. And on the 1st of January, I ask for a valuation of it, and it's £100,000. During the calendar year, I put in £20,000. And on the 31st of December, I ask for a revised valuation of my pension fund. And I'm told, to my great delight, that it's now worth £150,000. Now, I've only put in £20,000. Looking at it crudely, 30,000 is passive growth. But even on your approach, that's all matrimonial property. Passive growth is coming in there. But you say not all passive growth comes in. Is there an inconsistency?
The justification for the situation is that passive growth on matrimonial property is included. Passive growth on non-matrimonial property is not included. It's Bachtimal and Friends' Rembrandt. If the Rembrandt on the wall is not matrimonial property, it doesn't matter in the slightest that it's doubled in value during the marriage. What I am aiming at in my argument is consistency between different sorts of matrimonial property. Between the Rembrandt on the wall...
I think we've grasped that point, Mrs. Scott. You are. It's exactly what you're trying to do.
Indeed, yes. And I entirely accept that when one looks at these regulations, this is fairly crude. But it's important to the practitioner and it's important to the litigant because it gives a clear and precise starting point to put into your section 91A calculation to deal with financial provision on divorce.
Of course, Mr. Mitchell's calculation is even simpler than yours, isn't it?
But Mr. Mitchell's calculation suffers from the problem that it ignores part of...
Well, we understand that is your other argument, yes.
Well, of course it is, yes. But quite.
With the simplicity and certainty, practitioners, should Mr. Mitchell turn out to be right, practitioners would have no more difficulty with it, would they? It would be quite easy.
They would, because on Mr. Mitchell's argument, what we would end up with is a great deal more reference to section 10.6, which is what is accepted by Lady Smith. And so one's back into the Jacks against Jacks and how much of this should be included. And we will get a greater measure of argument about that in my submission.
Well, you might.
The oddity of Mr. Mitchell's point is also illustrated, and perhaps we're just trading weird examples here, of the one I've put in at my footnote 65 of... yes, footnote on page 65. And this is more pertinent to the present situation because it gives the example of a private pension fund where there is a pension in payment. And the example I take is of a pension fund which is accrued over a period of 10 years before the marriage, 5 years into the marriage, and then there's a retiral. And if one's doing a calculation at that point of how much of that pension is referable to the period of the marriage, it would be 1/3, giving you a pension value of £50,000 to put in. But if the pensioner then retired and continued in the marriage for another 5 years, and as a result the pension pot, that being a private pension pot, had been reduced to £100,000, on Mr. Mitchell's calculation, half the pot would be referable. And it would still be worth £50,000, notwithstanding that a proportion of the pension fund had already been spent. So we have difficulties in whichever way we do it. But it's my submission that the interpretation adopted by Sheriff Holligan, the majority, and in some degree by Sheriff Kelly, is more consistent with what we have of the 1985 Act and the regulations than the position from Learned Friends. In my submission, and this is now coming to the point of the regulation, the appellant is putting the focus on membership when the focus of the regulations and the legislation is on the period. And we're looking at a fraction which the regulation base upon periods. And the difficulty that we all face is that the draftsman has used member in my submission as a portmanteau word. Member is not going to be easily applied to a number of the pension arrangements which are covered by the regulation. For example, one cannot really be a member if one's a person with rights in a retirement annuity contract or an insurance policy, which are both part of the Regulation 3 set of valuations. It's an odd word to use. But the draftsman is dealing with a whole range of possible pension interests, which is why one cannot focus on member, and one has to say not what does the term member say in ordinary parlance, but what does it mean in the context of trying to identify a period. And so it's irrelevant in my submission to look at the legislation relating to occupational pensions, or a fortiori, the word member in this particular scheme, which is contributory member. The word member denotes a broader concept. And in my submission, if one can accept that member is a portmanteau word, one has to look at other parts of the regulation to secure the clue to what the draftsman means by the use of that word member. And he tells us two things which in my submission support the respondent's argument. And the first is that we're looking at a period that falls potentially within the period of the marriage. The draftsman does not use the word in B, period of the marriage. In Learned Friends' arguments, it is necessary to read B short as simply the period of the marriage. One cannot read the whole of the phrase within the period of the marriage because it doesn't work. One can't have it within the period of the marriage on the Learned Friends' argument. And the second clue that the draftsman gives us is the zero. And the court has my point that the draftsman must have in mind the commonly encountered circumstances of pension rights which have accrued entirely before a marriage. It's fairly clear and obvious in my submission. And neither of those things is allowed for in the Learned Friends' argument. In my submission, this is a classic case where the draftsman has used that portmanteau word to avoid prolixity, and this is, in my submission, spot on a Quinta Valle case. I expect the court is more familiar than I am with the Quinta Valle case, but does the court wish to be referred simply to the relevant paragraph?
I don't think any of us were in it.
Right.
I certainly wasn't because they objected to me.
I say, tab 26.
Tab?
26.
26.
And the passage that I rely on is paragraph 8 on page 480. The basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. But that's not to say attention should be confined and a literal interpretation given to particular provisions which give rise to difficulty. Such an approach not only encourages immense prolixity in drafting, since the draftsman will feel obliged to provide expressly for every contingency that may possibly arise, it may also, under the banner of loyalty to the will of Parliament, lead to the frustration of that will, because undue concentration on the minutiae of the enactment may lead the court to neglect the purpose which Parliament was intended to achieve when it enacted the statute. Every statute other than the pure consolidation statute is, after all, enacted to make some change or address some problem or remove some blemish or effect some improvement in the national life. The court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. And in my submission, that paragraph from Lord Bingham encapsulates the respondent's argument in this particular case. If we endeavour to apply the so-called literal interpretation to Regulation 4 with reference to the terms used in relation to occupational pensions, then we have difficulties with other types of pensions. We have to take the meaning from the context. In my submissions, one looking at this particular regulation in terms of its total context, the mischief it was designed to address, the draftsman might have tried to find a better term or to spell out what he meant in relation to every sort of pension. But in my submission, there is sufficient clue there within the terms of the regulation to understand what he means. And what he means in my submission is the interpretation which is given in this case by the respondent. And what follows in my submission is that when this regulation is applied to Mr. McDonald, Mr. and Mrs. McDonald's case, we have B as the period when contributions were made to this occupational pension, the 5 months, the period preceding the marriage and the 5 months of the marriage, because that, as it happens, is active membership of the scheme, which is the interpretation given by Sheriff Holligan, by Lord Malcolm, supported by Sheriff Principal Abercrombie.
How, in the end, do you deal with the private pension scheme? How do you deal with the fact that during the marriage, the husband may pay into his private pension scheme for the first 2 years, then not for the next 4 years, then for the 7th year, then not for up until the 10th year, and so on? What answer should we write down as being your way of sorting that?
My response to that is that, unfortunately, is one of the cases we're going to have to determine on the facts.
I see.
If one looks at some private pension schemes, one has a regular contribution every month. They're easy. The sort of pension scheme my Lord has cited, it may be that the pension scheme is one where it is open to the member to make such irregular contributions, in which case one would probably say that is a period of membership which encompasses the whole of the period making the contributions, perhaps even to the relevant date. It may be that these are a series of single contribution pensions.
Why? How can you say that, if in fact all this is related to contributions and there were vast gaps when no contributions were made? How can you say that, Mrs. Scott?
One would have to determine whether or not the pension fund, one interpreted the pension fund as being a series of single contribution pensions. One could do it that way. That would be a relatively straightforward way of doing it. But one would have to look at the precise circumstances of each pension fund. And as Lord Malcolm says, there may be difficult questions to determine on the facts. One might say...
The purpose was to keep it simple. This may not be a Rolls-Royce thing, but your approach is a good deal more complex than it seems the legislation was aiming at.
On the other hand, the vast majority of pension schemes that we're dealing with are occupational pension schemes.
Well, increasingly, people are self-employed.
Indeed. But in 1996 and in 2000, we were still dealing with, in the main with occupational pension schemes, and many of these were defined benefits. I appreciate that we've now moved to a different sort of scheme with defined contributions, and there may be more private pension schemes.
The original Act focused on occupational pension schemes and like arrangements. But I think it was in 1995, before the 1996 regulations, that the original Act was amended and Section 10.5 took on a form closer to that which it is now, where the focus moved away from occupational pension schemes.
10.5, with respect, didn't change, but 10.8 was introduced.
Well, didn't they change it to pension arrangement?
Yes,
I think that was 1995.
it was 1995, that's correct.
Well,
and the
That's
pension
a change from
yes.
that's a substantial change, I would have thought, from the original focus on occupational pension schemes.
Well, indeed. Indeed. And the original definition of pension arrangement was in section 10, and it was moved in the 1999 changes to section 27.1. But as I understand the position, as it's understood for the respondent, that was not intended to effect a substantive change. One was still looking at section 10.5 and the intentions in section 10.5.
But we must assume, must we not, that the drafter of this subordinate legislation in 1996 would be aware that he or she was dealing with pension arrangements as defined in section 27, subsection 1.
Interestingly, the 1996 regulations, and the court has them, don't cover the full range.
No,
They
covers more than occupational schemes.
Yes, and actually find them. Thank you very much. Tab 9. It's a very much more truncated form. If one looks at manuscript page 191,
Yes.
one finds that the valuation exercise in Regulation 3 covers active members of occupational pension schemes, deferred members, and then personal pension schemes. Then anything else to be calculated by the court by such method as it shall see fit. And the fraction is exactly the same as in the current regulations. But my argument remains that the intention of the draftsman was focused originally and still principally upon the occupational pension scheme, which is the most common case. There's one other difficulty which perhaps in fairness I should address, and that's state scheme rights, which of course are relatively insignificant because we're dealing with the relatively small, what used to be SERPs and then became additional pension and will become even less significant after 2016 when we're dealing with protected pensions. But my argument on that is we still have a position where the draftsman has left the possibility of B being 0 or a period within the marriage. And as my learned friend concedes, we're dealing with periods of contribution in relation to state schemes. So my position is that there's no literal interpretation of Regulation 4 possible, that there is a necessity to interpret by reference to context, and the context includes the whole scheme. And it remains that the interpretation should be as near as possible to the treatment of other matrimonial property in terms of section 9.1a of the Act. And that notwithstanding the difficulties, the interpretation proposed by the respondent preserves the greatest clarity and certainty consistent with the regulation and is consistent with the reason, the mischief addressed by the regulations. Now, I've been even briefer than my learned friend, unless I can assist the court further.
Well, many thanks indeed, Mrs. Scott. I gather not. Thank you very much. Miss Malcolm, have you anything to add? Mr. Mitchell?
If I may, just a few points by way of footnotes to matters that were raised. The question of how we deal on the respondent's example with the shareholdings and the assets of that kind, which have been acquired before marriage. It's interesting on this to note what Professor Clive said about that. I referred to his article without taking you to the passage, but it's in the authorities at MS 527, I think. And
Tab 32.
yes, thank you, my lord. Yes, which begins at 5223, which is a riposte by Professor Clive, whose expertise in this field is notorious, but he makes the point, of course, in the article, that if this act is any single architect, it is indeed he. And he makes the point at page 527, about 3/4 of the way, well, that's about 2/3 of the way down, in his commentary upon Lord Hope's discussion in Miller and Macfarlane, that the Scottish Law Commission was not trying to reduce the court's discretion to any such minimum. It was trying to achieve a satisfactory balance between principle and discretion. So that was so even then. But then, interestingly, the next paragraph, Lord Hope gives as an example of injustice the situation where the spouse's assets owned at the time of the marriage or inherited increase in value during the marriage, and the increase in value is not within the sharing principle. That is a fair point, but finding a solution is not easy. The problem was carefully considered in the recent review of Scottish family law, and in the end it was decided that all of the proposed alternative solutions involved more disadvantages than the existing rule. Now, though it's clear law, it's far from clear that it is across the board clear justice. There are many examples of cases where something is owned before the marriage, but it has become, in a true sense, a family asset. The matrimonial home is the example on the face of the statute. Another example is the country cottage, used for many years, money poured into its improvement from the matrimonial kitty. And at the end, that improvement, paid for by matrimonial money, stays out of the matrimonial kitty. It's the flip side to what I described as the dividends treatment. Now, so much for the analysis of what happens in the shares cases latter up to Wilson that were pointed to. The next point, which was a point of language, which I wanted to mention, returns to the statutory definition. And it is said by Mrs. Scott that my reading of the definition of B was to limit B simply to the period of the marriage. Now, my lady and my lords will not, I think, wish to be taken back yet again to a reading of this, but I don't. What we have in B is a sort of Venn diagram. You have a circle of what is the period of membership. You have a circle of what is the period of the marriage before the relevant date. And it's the intersection of these that is B. So in a sense, it is both. It has to be both. But I get to zero by pointing out, however far-fetched this may be, that one can get a zero on the intersection through the route, the period of the marriage before the relevant date. I'm not sure that I need say much more about this, except that something which was in my case, and I didn't take you to for in the interest of brevity, was the explanatory note. And the explanatory note to the 2000 regulations made it perfectly clear again that it never occurred to the draftsman.
Mr. Mitchell, remind us, what is the ability of a court to take note of an explanatory note?
That is, if I can just give you the citation, the court has the ability to look at it as a statement of the draftsman's intention, and it's approved by Parliament. It's in a footnote. The authority for that is in a footnote. Yes, it's at page 45, footnote 30.
Thank you.
We haven't put the case in.
No. Okay.
Yes. Lady Smith pointed to this. In English, it is Western Isles Council against Scottish ministers. And the explanatory note itself is at MS 129.
129.
129.
Oh, sorry.
Yes, 129. Penultimate paragraph. Provision is made apportioning the value of the benefits in accordance with the period of time the party in the pension arrangement has been in both the pension arrangement and in the marriage as a proportion. So the draftsman's gloss at that point is that what he or she is looking at in the concept, the period of membership, is simply has been in the pension arrangement, which is simply another formulation for my approach. Now, the next footnote, in a sense, is a more substantive one. Mrs. Scott's answer to my Lord Wilson's questions as to how one deals with the private pensions. Now, by way of preface, although she put it as the later part of her answer, she discounts their importance, saying this is really primarily all about occupational pensions. But it just hasn't been about that. There's been a change, of course, within occupational pensions from the final salary, the defined benefits approach, to defined contributions. And in a sense, one gets in the defined contributions occupational pension something which comes close to the problems of the personal pension for the purposes of her example. But the fact is that increasingly the percentage of people in the defined benefits occupational pension has been dropping nationwide, in Scotland as in Britain as a whole. The percentage in the defined contributions, which is a hybrid in a sense, the personal pension arrangement, has been increasing. But furthermore, the percentage of personal pension arrangements as compared to occupational has been increasing. Now, I don't know what the relative percentages, proportions are, but they are clearly substantial. And I certainly recall, although this is not a case in which the meaning of the regulation is to be determined by statistics, that by the turn of the century, over 9 million people in Britain were in personal pension schemes. They are common, not simply because of self-employment. Of course, it's increasingly common in the employment context. Indeed, the statutes now provide, the pension statutes, for personal pension schemes to be provided on a tripartite basis between employer, employee, and a scheme. Now, we have to deal with this issue. The regulations make it plain that it has to be dealt with. Now, we hear with great respect, extraordinary concession that it's enough in that context, or it may be enough, she doesn't have an answer, that the private pension scheme is one in which it is open to the member to make regular contributions. Now, while I dare say that there are private pension schemes in which it is not open to a member to make repeated contributions, that must be exceptional. it would only really apply to closed funds. I think the Equitable Life might be an example. In the ordinary way, a private pension scheme, you have the right to make whatever pensions you wish to do, whenever you wish to do, subject, of course, to rules such as lifetime allowance. Her definition accordingly seems to carry the consequence that if the person with the pension fund membership had membership of a private pension, we would loop back to the result I argue for. They would have put in 100,000 before the marriage. They had the right, as an aspect of membership, to make further payments, but never did. But because it's open to them to make contributions, we still have the timeline split. And we then end up with an extraordinary bifurcation of results within personal pensions. That the person whose personal pension was with the Equitable Life is treated one way. The person whose personal pension is in a SIP with Hargreaves Lansdowne is treated a completely different way. There's no suggestion that there can be any logical basis for that distinction at all. And it's said that one must look accordingly at the precise circumstances of the particular fund. We've looped back to a far more difficult approach to special circumstances than was there on my initial position. My position is simpler. It has the flexibility of special circumstances. Something was said by Mrs. Scott, effectively ex cathedra, about how enormously difficult Scottish family lawyers might find that, which, with great respect, I don't know that people in general do. We know that there is a balance, as Professor Clive put it, between principle and discretion. We know that special circumstances must always, in principle, be considered. And if one gets away from what was practically a starting position on this, that all Scottish family lawyers knew that her position was correct because it made perfect sense, because they knew one had to be put it to its side. I don't need to riposte with myself, but I can say it wasn't obvious in that way to Lady Smith. And when I ask why isn't it obvious, it's because the whole scheme of this is to recognise that one is dealing with something different to the shares, the Rembrandts. One is dealing with something in which one must take a proportion of something which in truth doesn't really exist. A couple of, as a right, as a property right. Something Lord Marnock made mention of in the cases that were put before you was a conceptual difficulty in dealing with incorporeal property rights, where one didn't in truth have property in the thing it was that was being brought into valuation. Pensions have always been an example of such. I recall right back Little Against Little, which was the earliest of these cases, one of mine, which was the case which really, I think, made plain to the profession that pension rights were very valuable potentially, quite difficult, and required actuarial evidence in that case on both sides. And I recall, and I'm sorry to reduce this to anecdote, my discussions on this, my conversation with Lord Cameron, who was the Lord Ordinary, about the conceptual problem of putting value upon something which could only ever be regarded as a hope, as a space, that one might die before this was ever achieved. It has always been seen as something which cannot really be put into the same box, and that is what the regulations do. They recognise it's not the same box, they recognise the need for special treatment, and that is why we have regulations, and that is why we have the timeline.
Can I just understand how special circumstances come in a case like this?
Yes.
I mean, is one of the special circumstances the fact that the contributions predate the marriage. Is that?
That has to be what is said. With respect, however, though, it's quite difficult for me to answer that question for this reason. Under the scheme of the Act, it is always open to somebody to argue that there are special circumstances to depart from an equal split in matrimonial property. In this particular case, the sheriff decided this in such a manner that special circumstances could not come into his judgment. When it went to the inner house, that is noticed, and accordingly it was pointed out by the court that if the respondent now, the pursuer, was to make any argument on special circumstances, that would really have to be dealt with of new.
Well, I understand that we're not dealing with it. I'm just trying to
No, I understand.
see how it might come in. But
yes, my difficulty, in truth, is that I don't fully see how the argument would be developed for the respondent on this going back to the sheriff. Some cases have been put in. Stewart is an example. Stewart against Stewart, Sheriff Principal Young, so Stephen Young, that suggest that one cannot in truth argue special circumstances by simply saying the law is not fair. And that might be the totality of what is being said on the
Well, it's
suicide.
difficult for us to speculate.
Can't speculate.
What of the features of subsection 6 might be argued.
Indeed. All I said, as a matter of general principle, it is potentially there as a solvent for arguments of hardship and exceptionality, speciality rather, on the pursuer's side. But because one has to have the matrimonial property there, because special circumstances can only bite upon what one has in matrimonial property, it certainly cannot possibly have any effect on the case the other way round. And I think it was accepted. I noticed Mrs. Scott nodding when I said this. It's common ground that the majority in Inner House was simply wrong in suggesting that it could. But returning accordingly to where we're at, in my submission, what we have here is not a Rolls-Royce solution. It is designed to get away from the Rolls-Royce, and it does so in a manner that simply applies a timeline division in a context to which perhaps any particular bright line would have objections, and it leaves it at that. And there is nothing intrinsically unjust in a bright line which is based on a time division, which is A, the simplest and cheapest to achieve, and B, in a way reverberates back into an old problem about whether one should treat differently the short marriage and the long marriage. This has been an asset in a very long marriage. It's been something upon which the defender could rely. She already acquired benefit from it over the period of that marriage because she shared in the income from it. And it's in a way anomalous then that if she has that right to share, that stops. The widow's benefit point, which my Lord Wilson pointed to, is another. I fully accept these are not perfect solutions. The search for perfection is a search for the rainbow's end. I think you have my submissions.
Thank you very much indeed, Mr. Mitchell. Thank everybody for their very helpful submissions, and in particular for keeping to such a tight timetable, in which I hope everybody feels that they have had enough time to have their fair say. We will now go away and try and work out not what the Rolls-Royce solution is, but what the right solution is. Court is now adjourned.